Hello, my name is Damon Moore, and I am your presenter, and I'm excited to bring you this presentation on Texas child support laws. The information that's available in this presentation is perfect if you're thinking about creating your own, or I should say, it's perfect if you're thinking about representing yourself in court. The information is also helpful if you are going to be talking to the Attorney General and you want to uh, uh, arm yourself with information that can help you in that meeting. It's also great information if you're going to be hiring an attorney and you want to put yourself in a position to be able to provide or I should say, if you want to put yourself in a position to be able to help that attorney to help you. So I'll tell you a little bit about who I am. I own the law office of Damon Moore. My team has an office in Austin, Texas, and we handle family law matters throughout the state. Uh, I've been representing clients in family law or domestic relations matters since 2005. I've represented hundreds of people in divorces, child custody matters, termination of parental rights and adoptions. I'm also a mediator. So I want you to know that you're in good hands as we venture into this topic. I have several videos that you can watch to learn about about a wide range of family law topics. I also have articles on my website that discuss topics in family law and other topics as well. But in this presentation, I'm going to talk to you about Texas child support laws. Before I do that, however, I'm going to give you a little bit of information about conservatorship, or what people in the streets like to call custody, so that way you'll have some context for the discussion about child support. Conservatorship is a term used in Texas to address the legal and physical aspects of sharing children and managing the children's affairs. If you want to learn more about conservatorship, then you should check out my video on conservatorship. For now, I will tell you that there are numerous legal and physical aspects of sharing the children. Or I suppose I should say there are numerous rights and duties. Those rights are not always shared equally. One of those rights that's not shared equally is the right to collect child support. Now, it's important to understand that the Texas the Texas Family Code says that a court can order one or both parents to pay child support. However, unless you have a situation in which both parents are paying child support to a third party, it is unlikely that both parents will pay child support. And the practical reality is that the practical reality is that one parent is going to have the right to collect child support. You also need to know that judges tend to determine child support by taking your net resources and applying the Texas child support guidelines to those net resources. Here's how you calculate net resources. First, you want to look at your resources. Now, your resources include 100% of all wage and salary income and other compensation for personal services, including commissions, overtime pay, tips, and bonuses. And before I continue, I should say what I've done here is I've taken a screenshot of a sample of something that is called a proposed support order, and a lot of times lawyers will use this form to write the information down that they need to write as they come up with a proposed child support order. So I mentioned the 100% of the wage and salary income. This is part of what would go into that form. You'd also look at the interest, dividends, and royalty income. You'd look at self-employment income, and you would look at net rental income, and that's kind of defined as the rent after you deduct operating expenses and mortgage payments, but it doesn't include some other things such as non-cash items like depreciation. And you look at all other income that's actually being received, including severance pay, retirement benefits, pensions, trust income, annuities, capital gains, Social Security benefits, uh, and a number of other items. You should note that the Texas Family Code says that whenever it's feasible, gross income should first be computed on an annual basis, and then it should be recalculated to determine what the monthly gross income is. You know what? Before I continue on to the next slide, I want to go back and talk about this section. You're looking at number 5 on the slide, all other income actually received. I want to provide a little bit more detail on that because I know some of you are going to be using this in an effort to try to represent yourselves. So I want to describe in more detail what all other income could include. So all other income, including severance pay, retirement benefits, pensions, trust income, annuities, capital gains, Social Security benefits, and other supplemental security income, United States Department of Veteran Affairs disability benefits, other than non-service connected disability pension benefits that's defined in 38 USC section 101 parentheses 17. Unemployment benefits, disability and workers' compensation benefits, interest income from notes regardless of the source, gifts and prizes, spousal maintenance, and alimony. So I started to go through that quickly, but then it occurred to me that some people will use this to represent themselves, so I want to make sure that I provide as much of that information as I can. And I should also add that what I gave to you, or the information I gave to you, does come out of the Texas Family Code. So that information can be found there, although it may be a little bit more complicated to read through. Once you have calculated the resources, the Texas Family Code says the court shall deduct the following items from resources to determine the net resources that are available for child support. Social Security taxes, federal income tax that's based on the tax rate for a single person that's claiming one personal exemption, and the standard deduction. State income tax, union dues, expenses for the cost of health insurance, dental insurance, or cash medical support for the obligor's child that's ordered under section 154.182 and 154.1825. And if the obligor does not pay Social Security taxes, then non-discretionary retirement plan contributions. So once the judge knows the net resources available to the person paying the support, the court will apply the child support guidelines. And so here's the child support guidelines. If you've got one child, they're going to take a look at that net resources amount, and then they're going to say, okay, 20% of that net resources amount should be your child support obligation. If you have 2 children, then they're going to take 25% of your net resources. 3 children will cause the court to take 30% of the net resources. 4 children, 35% of the net resources. If there's 5 children, you're looking at 40% of the obligor's net resources. And if there are 6 or more children, they're going to take not less than 40% of the obligor's net resources. The Texas Family Code says the amount of a child support payment established by the child support guidelines that's in effect in Texas at the time of the hearing is presumed to be reasonable, and an order of support conforming to the guidelines is presumed to be in the best interest of the child. Now, you may be wondering whether it's possible to get the judge to order more or less child support than what the Texas child support guidelines suggest that the judge should order. Yes, it is possible. The Texas Family Code says the court may order periodic child support payments in an amount other than that established by the guidelines if the evidence rebuts the presumption that the application of the guidelines is in the best interest of the child and justifies variance from the guidelines. There are circumstances in which the court will depart from the child support guidelines, but you are going to have to give the court a reason to depart from the guidelines if that is what you want. Are you ready to learn how to do that? Great. I'm going to give you a list of factors that the judge considers when determining whether he or she should order a child support amount that is different from the guidelines. You need to look at this list, and if you want the judge to give you more child support, or you want the judge to reduce your child support obligation, then you need to argue that something in this list is so important that the judge needs to order more or less than the guidelines suggest. So here's the list. The needs, or the age and needs of the child, the ability of the parents to contribute to the support of the child, any resources, any financial resources available for the support of the child, the amount of time, of possession of, and access to the child, the amount of the obligee's net resources, including earning potential of the obligee, if the actual income of the obligee is sufficiently less than what the obligee could earn because the obligee is intentionally unemployed or underemployed. Child care expenses incurred by either party in order to maintain gainful employment, whether either party has the managing conservator or actual physical custody of another child, the amount of alimony or spousal maintenance actually and currently being paid or received by a party, the expenses for a son or daughter for education beyond secondary school, whether the obligor or obligee has an automobile or housing or other benefits furnished by his or her employer, another person, or a business entity. And there's some other ones, but before I switch to the slide, I want to kind of hone in, or before I switch to the next slide, I want to focus on a few of the things that I just said in this slide. In my practice, the age and needs of the child tend to be something that comes up in court often. And number two, the ability of the parents to contribute, that's something that comes up often. Number three, it comes up often, the financial resources that are available. Number four, the amount of time and possession and access to the child, that one comes up a lot. And you'll find that this is an area of particular debate, because one thing that the opposing party likes to do, or this may be you if it fits your situation, somebody is always trying to argue that if you're the father or you're the person that traditionally seems to not be awarded the child, you're trying to make an argument that the time that you spend with the child is is the same as the time that the mother is spending with the child. And what will happen is one party will make that argument. Let's say you're the father and the mother has possession of the child. You're wanting to make the argument that you spend half or more than half of the time with the child, and that because of that, the child support guidelines are inappropriate, and the amount of child support should be adjusted. Similarly, if you're the mother or you're the father and you've got uh, an unusually high amount of time with the child, you might want to make the argument that additional child support should be paid because you are in possession of the child for a longer period than what you think those child support guidelines was based on. So that number 4 is something that gets debated often. Number 5 is something that gets debated often because in many instances, one parent is claiming that the other parent is intentionally not working, or they're claiming that the person is being paid under the table, or in some way that the obligor is paying less money, purposely trying to pay less or show less income than they really make. Number 6, I've noticed that one a lot in my practice. Child support or child care guidelines or child care expenses is something that a party may have to take on in order to maintain employment. If you're the person that's paying child care so that you can have a job, then you want the court to take that into account. And that is regularly argued. And sometimes I've been able to argue that a parent should have, let's say a parent who's in possession of the child or determining where the child resides, I've been able to argue that that parent should have reimbursement for child care and should also have child support. So sometimes depending on your situation, you're able to make that argument effectively. Other times you're not. It just kind of depends on the circumstances and what kind of argument you can make in line with those facts. Let me go to the next slide. The amount of other deductions for or from the wage or salary income and other compensation for personal services of the parties, provisions for health care insurance and payment of uninsured medical expenses, special or extraordinary educational, health care, or other expenses of the parties or of the child, the cost of travel in order to exercise possession of or access to the child, positive or negative cash flow from any real and personal property and assets, including a business and investments, debts or debt service assumed by either party, and any other reason consistent with the best interest of the child. Those things will be taken into consideration when you're dealing with cases like this. And I put, on the slide, I put any other reason in red because I think, as you're thinking about this situation, whether you're going to represent yourself or you're going to work with another attorney, you really want to look at the list that I've provided, but if you've got other items or other factors that you think a court should consider, then those things are going to be fair game too. So, everything that you can think of to depart from the guidelines is something that you should at least consider and discuss with your team, discuss with me, discuss with some other attorney. I think you could gain some value out of that. And that's all there is to it. If this information is helpful to you, then here's your next steps. I think first you want to subscribe. If you're looking at this through a YouTube channel, you want to subscribe to my channel so you can obtain additional information. If you are looking at this on a website and you've got the opportunity you have the opportunity to subscribe to a newsletter or something of that type, then you want to make sure that you do that. Or you want to send an email to me at damon@damonmoore.com. Yeah, I can certainly add you to a list, and as more information is produced, then we can pass that information along to you. If you're watching this through a YouTube channel, then you want to make sure that you press the like button. That's very helpful for us. It allows us to be able to get more information to others. That helps us understand whether this is the kind of thing that we should continue to make. You also want to make sure that you get my free relationship breakup tips guide if you are in a situation where you need information about breakup tips. If you've already ended a relationship or you're thinking about ending a relationship, the information could be useful because there's going to be some things in that guide that apply if you have a case pending. I am certain that there's going to be some good value for you in that breakup tips guide. In order to get that guide, you can look in the show notes if you are looking at this on YouTube. If you're not looking at it on YouTube, then you can if you're not looking at it on YouTube, then you can send me an email and you can request it again. That email address is damon@damonmoore.com. And my phone number is 512-333-2766. And my website is damonmoore.com. I hope that you've got some value out of this, and I look forward to talking to you in the future. Thank you.